Okay, so good everybody. I'm back for another video po ulit. So kagabi po kakagawa ko lang ng video, 'di ba, na wala pang announcement of any warrant of arrest or red notice sa Interpol. Pero kaninang umaga po pag-uwi ni FPRRD from Hong Kong, bigla po nagkaroon ng service of what appears to be an arrest warrant from the International Criminal Court. Okay? So ngayon po i-explain ko po sa inyo kung ano yung mga nakita kong possible legal issues and or defenses po against the warrant of arrest, against the Rome Statute, and mga possible constitutional issues din po na nakita ko dito. Okay, so discuss po natin lahat yan. So ngayon po kasi since medyo madami po tayong papag-usapan, iba-ibang provision, nilabas ko po yung kodigo ko dito para sigurado pong hindi tayo magkamali. So ngayon po i-explain ko muna sa inyo yung mga nakita ko dun sa warrant of arrest, okay? So under the warrant of arrest po from the ICC, specifically page 3, may kita po ninyo under procedural history, nakalagay po dyan, on 19 April 2021, the presidency assigned the situation in the Republic of the Philippines to the chamber. Tapos sa number 2, nakalagay po dyan, on 15 September 2021, the chamber authorized the commencement of an investigation into the situation in the Philippines. Okay? So again, take note po, April 2021 po nag-start yung mga proceedings sa ICC regarding the situation po in the Philippines involving former President Rodrigo Roa Duterte. Tapos kung makikita nyo rin po dito, nilagay po nila is that in relation to crimes within the jurisdiction of the court committed in the territory of the Philippines between 1 November 2011 and 16 March 2019. Take note po, yung date po na 16 March 2019 is very important po kasi ito yung date kung saan nag-take effect na yung withdrawal po ng Philippines dun sa International Criminal Court. Okay? So kung makikita po natin, nag-withdraw tayo March 16, 2019, tapos nag-start po yung mga investigation and proceedings sa ICC on 19 April 2021, 2 years po after the withdrawal po natin. Okay? So yung mga dates po na binanggit ko, yun yung nakalagay sa warrant mismo. Tapos kung pumunta rin po kayo sa ICC website under po dun sa investigation ng Republic of the Philippines, pag tingnan po ninyo yung court records doon, pumunta po kayo sa last page 2021 din po yung date na nag-start yung mga proceedings or yung mga matters po involving the situation in the Republic of the Philippines. Okay? And those dates po are very crucial, very important considering po under Article 127 of the Rome Statute po, ito po yung provision regarding the withdrawal of state parties from the Rome Statute. Okay? So dito po makikita natin as state, its withdrawal shall not affect any cooperation with the court in connection with criminal investigations and proceedings in relation to which the withdrawing state had a duty to cooperate. Tas ito pong next sentence yung important po talaga because ang sabi po dito, and which were commenced prior to the date on which the withdrawal became effective. Okay? So ang ibig sabihin po niyan, yung ICC po merong jurisdiction over investigation and proceedings na na-commence na po prior to the withdrawal of a state. Diba? So may kita po natin, nag-withdraw po tayo, formally po nag-withdraw tayo on March 2019 po, pero yung investigation and proceedings sa ICC only started in April 2021. So dito po naka-withdraw na tayo prior to the start of the investigation and the proceedings sa ICC. Therefore, pag ganyan po, wala nang jurisdiction supposedly yung ICC kasi considering under their provision nga po which were commenced prior to the date on which the withdrawal became effective. Diba? So again, ulitin ko po, yung mga investigations and proceedings that were already commenced prior to the withdrawal, yun lang po yung may jurisdiction over yung ICC. However, in this situation po, in the case of former President Rodrigo Roa Duterte, we withdrew on March 2019 pero yung investigation only started after the withdrawal on April 2021. Okay, so yan po yung pagkaintindi ko dito at yan po yung professional assessment ko of the case of FPRRD in relation dito sa Article 127 and the eventual issuance po of the arrest warrant against FPRRD. Okay? And this will be the quick reminder for this video guys. Kung nasa YouTube po kayo at nag-enjoy kayo sa videos ko, huwag niyo po kalimutan mag-subscribe. At kung nasa Facebook, TikTok, or Instagram po kayo, huwag niyo naman po kalimutan mag-follow. Okay? Tuloy po tayo sa discussion natin. So ngayon punta naman po tayo sa preamble ng Rome Statute. Okay? So nakalagay po dito sa preamble, specifically paragraph 10, nakalagay dyan, emphasizing that the International Criminal Court established under this statute shall be complementary to national criminal jurisdictions. Okay? So take note po, ang nakalagay po sa preamble ng Rome Statute mismo is that the ICC shall be complementary only to national criminal jurisdictions. Okay? After po niyan, ngayon punta naman po tayo sa Article 1 of the Rome Statute. So again, nakalagay po dito, the International Criminal Court shall be complementary to national criminal jurisdictions. So kung makikita po ninyo sa preamble at sa Article 1 pa lang ng Rome Statute, talagang ine-emphasize po nila na complementary lang po sila sa mga national criminal jurisdictions. Stated differently po, ibig sabihin po niyan, they will only complement and support the judicial systems po of mga member states sa Rome Statute. Okay? And the reason kung bakit ina-explain ko po yan sa inyo, para po at least mag-gets nyo talaga at maintindihan nyo kung ano ba talaga yung basis and foundation po nitong International Criminal Court. So ngayon punta na po tayo sa next defense of FPRRD regarding naman po to sa admissibility of his case in the International Criminal Court. Okay? So yung maging defense po dito is Article 17 of the Rome Statute, specifically the issues of admissibility. So may kita po nyo nakalagay talaga dito at in-emphasize sa Article 17 having regard to paragraph 10 of the preamble and Article 1. So yan po yung mga binasa ko kanina, di ba? Which emphasize that the ICC is only supplementary po to national criminal jurisdictions. Okay? So ito pong issues of admissibility, ibig sabihin po nito, ito yung mga situation kung saan yung ICC po ay pwede hawakan yung mga certain cases or hindi nila pwede hawakan. Okay? So dito po talagang importante sa Article 17 is paragraph 1 letter A of the Article 17. So dito po may kita natin, a case is inadmissible, meaning hindi po pwede tanggapin or i-admit sa ICC yung kaso when the case is being investigated or prosecuted by a state which has jurisdiction unless the state is unwilling or unable genuinely to carry out the investigation or prosecution. Okay? So kung sa Tagalog pa, ang sinasabi po dito is yung ICC po, ang isa pong kaso hindi pwede admit sa ICC kung ang isa pong bansa ay ini-investigate at prosecute na yung kasong yon at meron siyang jurisdiction talaga dun sa kasong yon. Unless na lang po na yung bansang yon hindi nila ini-investigate or prosecute ng maayos yung kaso involved. Okay? Ang next naman po is punta tayo sa paragraph 2 naman. Okay? So nakalagay po dito, to determine the unwillingness, the court shall consider principles of due process recognized by international law. Okay? Tas nagbigay po yan sila dito ng mga situations. So unang-una, the proceedings were or are being undertaken or the national decision was made for the purpose of shielding the person concerned from criminal responsibility for crimes. Okay? Letter B po, nakalagay dyan, unjustified delay in the proceedings. Tapos sa letter C naman, nakalagay dyan, the proceedings were not or are not being conducted independently or impartially. Okay? So yan po yung important provisions dito sa Article 17 na pwede pong gamiting defense ni FPRRD. Okay? So explain ko po sa inyo ng maayos. Ito pong provision na to, Article 17, ang pinaka-essence po talaga nito is ina-explain po ng Rome Statute na kung ano yung mga cases na hindi pwede i-admit or tanggapin ng ICC. Okay? And under this provision po, kung makikita po ninyo, if you take into consideration all the provisions that I cited, ang pinaka-essence po talaga niyan is if ang isa pong judicial system, ang prosecutorial arm, investigatory arm of a state ay hindi ginagampanan ng maayos yung trabaho nila, dun lang po pwede i-admit ang isang kaso na nasa jurisdiction din ng ICC. Okay? So ulitin ko po, pag ang judiciary po ng isang bansa ay hindi kaya maging impartial, hindi kaya mag-investigate ng maayos ng Department of Justice against an accused or halatang dinedelay talaga yung proceeding or halatang sinishield ang isang akusado sa isang krimen ng Department of Justice and or the judiciary, dun lang po pwede admit ang kaso na may jurisdiction din yung ICC. Okay? Ngayon tingnan po natin kung ano na ba talaga yung current situation sa bansa po natin in relation po to FPRRD as a private citizen. Unang-una is the state currently unwilling or unable to investigate or prosecute FPRRD po ba? Ito po based sa personal observations ko from the political happenings in our country, the news reports na nakikita po natin, hindi po unwilling and unable to investigate and or prosecute yung state or yung bansa po natin against FPRRD. Diba? Kung makikita nga po natin, diba, ang dami pong cases filed against FPRRD at ang dami din pong legislative inquiries conducted against directly involving FPRRD and Vice President Sara Duterte. So dun po sa number 1 yung unwilling or unable, dun pa lang po medyo malabo na mapakita na unwilling or unable yung Department of Justice to investigate and or prosecute FPRRD. Okay? So ngayon, ang next question naman po is whether or not the Department of Justice or the judiciary system natin are shielding FPRRD against the alleged crimes against him. Diba? At yung sagot po dyan, again, personal observation ko po to, I don't think the Department of Justice, the Philippine National Police, or the judiciary is shielding FPRRD simply because, again, ulitin ko po, ang dami pong cases filed against them. So dun pa lang po may kita talaga natin na gusto talaga i-prosecute at investigate ng PNP, ng Department of Justice, si FPRRD. Okay? So yung next issue naman po natin is kung meron bang unjustified delay sa investigation or prosecution against FPRRD. Again, kung ako po tatanungin based on my personal observations, wala pong unjustified delay, di ba? Yung nag-joke nga lang po si FPRRD, bigla na siyang pinaimbestigahan agad eh. Therefore, may kita natin again na there is a willingness po talaga to investigate and prosecute FPRRD, di ba? Kung meron meron mang delay so far against the cases filed against him, yung may trabaho po talaga niyan, yung Department of Justice to prosecute. So, nasa kanila po yung bola regarding that issue, okay? At yung last question or yung last issue po natin under this provision is kung impartial or biased ba yung nag-handle ng investigation and or prosecution. Again, ulitin ko po, based from my personal observation on what is happening po sa bansa natin, wala po akong nakikitang bias naman in favor of FPRRD, di ba? And the reason kung bakit wala po tayong nakikitang bias kasi ano naman po FPRRD clearly is the figurehead po of the opposition. Therefore, talagang may kita natin na may willingness po talaga mag-prosecute yung current admin against FPRRD for the alleged crimes that he committed. So, taking into consideration everything I have discussed po, ito po yung mga pwedeng defenses na gamitin ni FPRRD in relation po to the admissibility of his case in the International Criminal Court. Okay? So, may kita naman po natin as of the year 2025, former President Rodrigo Roa Duterte is already a private citizen. Therefore, wala na po siya sa poder. He is no longer an incumbent president. Consequently, he does not have the means or the capability na po para po i-shield siya ng Department of Justice or para po ma-delay niya yung mga investigations being conducted against him, di ba? Because again, FPRRD as of 2025 is already a private citizen, okay? So in short, iba na po yung panahon ngayon, okay? Kung 2016 to 2022 pa yung period ngayon, hindi ko na po yun questionin kasi of course, as a sitting president, you have all the means po talaga to shield or protect yourself from criminal prosecution, okay? But again, ulitin ko po, 2025 na po and si Mr. or si Attorney Rodrigo Roa Duterte is already a former president, thus he no longer has the means po talaga to shield or protect him from criminal prosecution, di ba? Plus the fact po na si FPRRD is the figurehead of the political opposition, so kung gugustuhin po talaga i-prosecute sa FPRRD, they really have the means and capabilities to do so, okay? So ngayon punta naman po tayo sa pwedeng gawing remedy ni FPRRD regarding the case po niya dun sa ICC, okay? So under Article 19 po nakalagay dito challenges to the jurisdiction of the court or the admissibility of a case. So number 2 po, challenges to the admissibility of a case on the grounds referred to in Article 17. An accused or a person for whom a warrant of arrest has been issued ay pwede po mag-challenge, diba? At kung makikita po natin today po, this morning, there appears to be a warrant of arrest from the ICC issued against FPRRD which was served also to him. Therefore, pwede na po niya i-challenge yung admissibility ng case niya based po dun sa mga binanggit ko under Article 17. Okay, so yan po yung next step na pwedeng gawin ni FPRRD. Ang problem lang po ni FPRRD is because nakalagay din po dun sa Rome Statute na yung action po niya to challenge the validity or the admissibility of his case hindi po maapektuhan yung validity ng warrant of arrest during the pendency of his challenge. Okay, so yan po yung dilemma ngayon ni FPRRD. So ngayon punta naman po tayo sa Constitution kasi meron po akong mga nakitang post kung saan sinasabi po under RA 9851 po ito po yung batas natin na nagpipinalize ng crimes against humanity, specifically Section 17 po of the said law kasi meron daw provision doon na pwede daw mag-waive yung state ng jurisdiction, ng investigatory or prosecutorial powers nila kung meron din pong international body na nagko-conduct ng investigation and or prosecution for the same case, okay? So now I am seeing arguments po na because of that provision, hindi po dapat i-try daw si FPRRD sa bansa natin, kundi dapat dun talaga sa International Criminal Court kasi yun nga po, pwede daw po mag-waive ng right to investigate and or prosecute ang isang state kung meron pong international body na nag-investigate and or prosecute of the same case, okay? So regarding that provision po, ang sagot ko lang po dyan is Article 2, Section 7 of the 1987 Constitution, okay? Yan po yung state policy natin regarding the foreign policy po of our state. At ang nakalagay po dyan, ang mandate po ng Constitution natin is that we must pursue an independent foreign policy. At yung main consideration po dyan in the pursuance of an independent foreign policy is unang-una po ma-preserve yung national sovereignty natin, national integrity, national interest po natin, and the right to self-determination po natin, okay? So yun pong apat na yun, pinaka-main reason kung bakit po tayo nagpo-pursue ng independent foreign policy, okay? So baka nagtataka po kayo bakit ina-explain ko tong foreign policy considering RA 9851, crime against humanity naman pinapag-usapan natin because Section 17 po nakalagay po doon, pwede daw natin i-waive yung right natin to investigate and or prosecute dun sa isang international body kung yung international body na yon ay ine-investigahan din or pinoprosecute yung same kaso na being discussed under RA 9851. And because of that po, because of that waiver to an international body, ang professional assessment ko po is that violates Section 7, Article 2. Because yun nga po, di ba, under Article 2, dapat po ang priority natin is independent foreign policy in relation to the four I mentioned. So specifically po dito, it can fall under national interest considering po yung judicial system natin, yung Department of Justice natin, yung investigatory and or prosecutorial system and or arm ng government natin, dapat po talaga ma-maintain yung independence nila as long as kaya naman nila gampanan yung function nila, okay? So stated differently po, ang pinaka-point ko po talaga dito, dapat po ang investigatory body natin, ang prosecutorial body natin, hindi po sumurrender ng power or ng function nila as long as they have the means to conduct their own investigation and to conduct their own prosecution of an accused, okay? Therefore, because of that, my professional assessment po is that Section 17 of RA 9851 can be argued as unconstitutional for violating po the state policy that we must pursue an independent foreign policy, okay? So again, ulitin ko po, dapat po independent tayo as much as possible. Wag po tayo umasa sa foreign powers as long as we have the means and capabilities to handle our own affairs, diba? Because we have to remember, we are an independent state and we are not a colony and or a controlled state by another country. Therefore, as much as possible, kung kaya natin, maging independent po talaga tayo, which includes our judicial and justice system. Okay? Okay, so hopefully klaro yun guys. If you like legal educational videos sa current events, follow lang po kayo sa akin sa social media. Until next time, see you all po. Bye-bye!